we're very happy to be here. It's always important to discuss all the legal matters in relation to the code application. So I'm very glad to have the opportunity to discuss this with you. My presentation will be mainly based on the way WADA review decision and what are we looking for in reviewing in particular, and why do we appeal or not the cases that we receive. So first, this is part of our mandate. WADA was created for harmonization of the anti-lipidem fight. So in particular, also, this is what I'm going to speak about the harmonization of sanction, because as you know, before the creation of WADA, depending on the sports, the country where you were tested, you sanctioned for the same violation. It could be from nothing to a life ban. So it's part of our mandate now that there are harmonized rules to ensure also a harmonized application of these rules among our 500 signatories, something like that. Okay. So what is WADA's role as regards harmonization? To establish rules and to ensure also that these rules are correctly implemented in the rules of the signatories, because our rules, the standards are self-applicable, but the rules of the World Anti-Doping Code have to be implemented in the signatories' rule. So what do we do is to issue rules, and then, and as you know, the code is not a document made by WADA, but it's made in consultation with all our stakeholders. It's a lively document. It's revised from time to time. First version in 2003. Then we had another version in 2007, and which entered into force in 2009. And as it was mentioned before, we are currently doing the third revision process for the new code to enter into force in 2015. So, I'll jump on that. As regards the statistics on our appeals, we received more or less 2,500 adverse analytical findings per year. Not all the adverse analytical findings lead to a decision, because there are sometimes TUEs which explain the findings. So, and if we take also into account the non-analytical findings, it means we review more or less 2,000 decisions per year. And the average of appeal lodged by WADA, as mentioned, as written here, between 20 and 40 decisions are appealed per year, which is between 1 and 2%. Most of the cases we appeal them before CAS. Now, due to the issue of cost before CAS, we also try to appeal as much as possible the cases before national level reviewing body, because as you know, now cases arising from a national case have to be paid by the parties before the CAS, which is really costly, not only for WADA, but also for the ADO defending the case, and also for the athlete. Sometimes, but it's very rare, we appeal decision before national federation internal bodies, and also before international federation internal tribunals, but it's quite rare. As regards South Africa, since the implementation of compliant rules in 2006, approximately 90 decisions have been rendered in South Africa. We have appealed 8 of them to date, and as you can see, most of our appeals have been admitted. We still have 4 pending cases now. And one case was brought directly to CAS by WADA. It was the Gertis case, and maybe you all know about this case. This athlete has lodged an appeal before size appeal body in May 2010, and WADA brought the case to the CAS in May 2011, since there were no decision at national level at that time. Why it is important for us that compliant, and for everyone, that compliant decisions are rendered. First, for harmonization, as I mentioned it, but also because the appeals process are very costly to everyone, and anti-doping authorities, WADA or any national anti-doping organization, has limited resources. Athletes and appeals are very costly for everyone, for the ADO defending its decision, for WADA, and also for the athletes who have to hire attorneys to defend this case. So, as mentioned, appeal before the CAS are even more costly, and this is the reason why. When correct decisions are rendered in the first instance, it's better for everyone because we can use the limited resource to other courses that are much more helpful for the fight against doping, like number of testing, education, or funding some research, which is also crucial. WADA is not appealing all the cases, first because we don't have the resources to do it, but only our goal is not to have all the cases reviewed by CAS, but just to ensure that the basic principle and rules of the code are correctly applied. This is why these are more or less the ground on which we appeal: misapplication of the rules or incorrect interpretation of the rules. For example, I will speak about that later in more detail, but for specified substances, there are two main conditions to be fulfilled. If one of these conditions is not fulfilled, we have no choice. We have to appeal to defend the correct application of this article. Or also, in case of exceptional circumstances where an athlete sanction was reduced for no reason or no reason set forth by the code, we also have no choice but to appeal that. And I would say that when there is a question of the appreciation of the tribunal between, for example, for a reprimand and 2-year ban for specified substance, or between 1 and 2 years in case of no significant fault or negligence, WADA will not appeal in any case. If there is a 12-month ban and we believe that it would have been better to have 14 months or 15 months, this is not the kind of cases we appeal if we consider that the panel has reviewed all the facts and circumstances. We would only appeal in case the sanction is evidently and grossly disproportionate to the offense. And it's important also to note that our role, the appealing role, it normally should be in the first place to the NATO itself. If NATO is not happy with the decision of its tribunal, or to the International Federation, I would say that WADA appeal should be subsidiary, really in case nobody appeals and where the decision is not appropriate. But this is also the reason why in the current version of the code, WADA has a longer deadline than any other party. This allows us to see what happens, and if there is a need for appeal and nobody goes, then we can exercise our right of appeal. But it's important that all stakeholders do their job in first instance and appeal the cases if necessary. An important thing to remind is that the standard sanction is always 2 years. Whatever it's specified, a refusal, or in any anti-doping rule violation, standard sanction is 2 years. There are situations where the sanction can be decreased, flexibility down, under several conditions. I will speak about some example later. And in other cases, the sanction can be increased, notably, for sure, if it's a case of repetition, if the problem involves a minor athlete, or in case of aggravating circumstances. But the basic sanction is always 2 years. Since the new version of the code entered into force in 2009, sometimes I have a feeling that there was some misunderstanding. People saying that there could be a much lesser sanction or much higher. It's true, but the basis where to start is always the 2-year ban. As mentioned in Article 3.1, when it's on the side of the anti-doping organization, it's the comfortable satisfaction criteria. But when the burden of proof is on the athlete, which is the case when he has to prove that his fault was not significant or that he did not intend to enhance his performance, then in any case for the athlete, it's always the balance of probability. So it's a bit less than the comfortable satisfaction, with the exception of the specified substance case and the intent, where the athlete wants to establish that he has no intent to enhance his performance. There, we go back to the criteria of comfortable satisfaction. The burden is a bit, the standard of proof is a bit higher. As regards this condition to have the sanction reduced, it should be applied very strictly. We see many cases where a panel reduced the sanction from 2 years to 1 year, for example, because of the good behavior of the athlete at the hearing. This has nothing to do with the fault, the degree of fault, or because the athlete, the panel found that the athlete was honest, nothing to do either with the degree of fault, or that yet it has no previous record, again, it has nothing to do with the degree of fault. So it's very important always to focus on this specific aspect.